We do appearances?
We have not.
Please to vote for the people.
I'm Jeff Harrison. I'm here on behalf of Jacob Bradley Johnson. He's next to me at the table.
Thank you. All right, we're here today for a final pretrial conference. This case is one of those currently set for the next trial date here in Wexford County. I've been handed by Mr. Harrison a signed and written pretrial agreement and his decisive rights. It says that the defendant, who is charged in count 1 with assault with intent to do great bodily harm less than murder or by strangulation, that count will be dismissed if the defendant enters a plea of, is that guilty or not guilty? You check both blocks.
It's no contest, Your Honor.
Thank you.
I'm sorry.
That's okay.
I also tried to sign the plea agreement on the wrong line.
I see. Okay.
So that was probably, I needed one more cup of coffee before I started dealing with that.
Did you get that cup of coffee?
I did. I'm fine now. Thank you.
I just want to make sure we're safe. Okay. And then the alternative is pleading to a added count 2 of aggravated domestic violence, and that is a felony punishable by up to a year. I'm sorry, a misdemeanor punishable by up to 1 year and $1,000. Is that correct, Mr. Harrison?
That is correct.
And there's also it says an agreement that the defendant would be sentenced to HYTA. Is that a kilobrew or is that just not objection?
My understanding that was a kilobrew. You disabused me of that notion.
In other words, if I don't go along with it, what are his rights?
I think my intention was a kilobrew.
Okay. All right. Thank you. All right, so did I get a complete and accurate statement, Ms. Dahl?
Please say yes.
Mr. Harrison?
Yes, you did.
Mr. Johnson, is that how you wish to resolve today's case?
Yes, Your Honor.
Please raise your right hand to the best you can. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. Sir, looking back on December 7th of 2025, were you on probation or parole at that time?
No, Your Honor.
Were you on bond pending any felony charges?
No, Your Honor.
You are currently charged on a piece of paper called a felony information, and on it there is one count. That count charges you with assault with intent to do great bodily harm less than murder, or, and as I understand it's the or that's applicable, or by strangulation. Now that's a felony punishable by up to 10 years and or up to $5,000. Now I'm told that charge will be dismissed if you enter a plea, and again, was it guilty or no contest?
No contest.
If you enter a plea of no contest to an added count 2. That added count 2 would be to a single count of aggravated domestic violence. Now, aggravated domestic violence is a lot like aggravated assault. It requires that the person sustained some injury. Now, that is a misdemeanor punishable by up to 1 year and or up to $1,000. Is that what you understood so far?
Yes, Your Honor.
Now, let's talk about a no contest plea. A no contest plea has the same impact as a guilty plea. The difference is, instead of requiring you to recite a factual basis to support the plea, I'm going to look at something such as a police report. Now, I can take a no contest plea with a couple certain circumstances. Mr. Harrison?
This case reeks of potential civil liability. The victim in this matter is Mr. Johnson's father, and there's been a history between them.
Ms. Dahl, is that your understanding as well?
Yes, Your Honor.
Now, when I take the no contest plea, one of the attorneys here is going to give me a police report, most likely. Or am I going to take judicial notice of the probation of the preliminary examination transcript.
That's correct.
That's what we would ask, Your Honor.
Well, that's important, Mr. Johnson, because if I admit this transcript as an exhibit, it, for all intents and purposes, becomes the truth for this case. For instance, we come back for sentencing. You can't come back and say, well, I didn't really do it. I just did it to take the plea. I can't do that. You understand?
Yes, Your Honor.
You also can't come back and say, well, I did this, but I didn't do that part. You understand that?
Yes, Your Honor.
So whatever is in here is going to be considered the truth as to this file. You understand?
Yes, Your Honor.
Okay. Now, by entering, I'm sorry, I've just gone over the pretrial agreement, but there's except for one portion. And there's what's called a Killebrew agreement as to sentencing. Now, the Killebrew agreement is between you and the prosecutor. I'm not a part of the agreement yet. I don't know anything about the case yet. So I don't commit myself until I know about the person, I hear from the victim, and I get to know more about the defendant. So, but the Killebrew agreement means that if I don't go along with the factor that you guys have agreed to, then you would, at that time, have the right to withdraw your plea. Now, the Killebrew agreement is that you will be placed upon HYTA status. HYTA stands for the Holmes Youthful Training Act. That means that the sentence is deferred. So instead of actually giving a final sentence, I would then place you into a period of probation. Technically, it's not probation. Technically, it's a deferral of sentence, but they could have the same conditions that are similar to probation. Can't possess drugs, use drugs, can't smoke weed, can't do alcohol. Maybe if I make you go to a treatment program or a rehab program or an anger management class or community health, something like that. And also that you can't violate any crimes. If you do, and I place you on the HYTA status and you violate those terms, then I can revoke that HYTA. Now, if you successfully complete it, then the charge gets dismissed and you never actually officially get a sentence. If you violate your terms or conditions and I put you on HYTA, I can revoke it and you're stuck with the sentence I give you. You understand?
Yes, Your Honor.
All right. Now, on this pretrial agreement here that I see that Mr. Harrison gave to me, over here, and I'm pointing to it, is that your signature?
Yes, Your Honor.
Did you read through all this before signing?
Yes, Your Honor.
And did Mr. Harrison, was he available to talk to you about the charges, the evidence, and the case, and your rights?
Yes, Your Honor.
And did he talk to you about the terms of this pretrial agreement?
Yes, Your Honor.
And are you satisfied with his advice and availability to you?
Yes, Your Honor.
All right. And so far, I haven't gone over everything, but so far, do you feel that entering this plea today is going to be in your best interest?
Yes, Your Honor.
Okay. Now, if you enter a plea of no contest today and I accept that plea, you will not have a trial of any kind. Does that make sense?
Yes, Your Honor.
Now I'm holding up another piece of paper that at the top says advice of rights, and I'm pointing here for you at the bottom. Is that your signature?
Yes, Your Honor.
Did you read through all these rights before signing?
Yes, Your Honor.
And did you understand all those rights that you read before you signed?
Yes, Your Honor.
And even more importantly, you understand that if you enter a plea of guilty today and I accept that plea, you will be forever waiving these rights as it applies to this particular case.
Yes, Your Honor.
All right. Additionally, you'll be given up the right to claim that the plea was a result of some promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to force or compel or encourage you to plead?
No, Your Honor.
Are you entering the plea here today of your own free choice?
Yes, Your Honor.
Now, in addition to talking about HYTA status, Mr. Harris has probably talked to you about potential sentencing based upon his experience. The key question that I have for you, however, is, has he or anyone made a promise to you as to exactly what the sentence would be from this court?
No, Your Honor.
Once again, you still wish to enter the plea that we discussed?
Yes.
Asked, and I caution you, just to remind you that I anticipate your response to be no contest. As to the added count 2, aggravated domestic violence, how do you plead?
Plead no contest, Your Honor.
Before the court can accept that plea, I need to have a piece of evidence here to consider. And Madam Court Reporter, if you could please mark the transcript that is in the court file with a sticker. Ms. Dahl, are you asking the court to admit plaintiff's exhibit, People's Exhibit number 1?
Yes, Your Honor.
Mr. Harrison, any objection?
None whatsoever, Your Honor.
That has now been marked by the court reporter, and People's Exhibit number 1 is hereby admitted. People's Exhibit number 1 is a transcript of the preliminary examination conducted before the Honorable Corey Wiggins of the 84th District Court on December 23rd of 2025. One moment. Ms. Dahl, do you believe that People's Exhibit number 1, I'm sorry, first, do you believe that the interests of justice again do not require the defendant to recite a factual basis?
Your Honor.
And do you believe that the contents of this Exhibit 1, again, the transcripts, include sufficient evidence to support a finding of guilt as to added count 2?
I do, Your Honor.
And are you aware of any other promises, threats, or inducements?
I am not.
Do you believe the court is in compliance with Scroll 6.302?
I do, Your Honor.
Mr. Harrison, do you agree with all those?
I do indeed, yes.
All right. The court agrees that the interests of justice do not require the defendant to recite a factual basis. The court also finds that the information contained within this report or in this transcript satisfy the required elements of proof. It talks about the victim being the defendant's father, and it provides detailed descriptions beginning on, looks like at least page 6 and continues through page 12. Talks about the defendant being choked, found and unconscious, having waking to a pool of blood that came from his face. Also that he had some injuries that required medical treatment, specifically bruising, knees, rib, right hand, right foot, and then his head when it hit apparently concrete. Therefore, the court finds the defendant's plea today is made freely, knowingly, and voluntarily. The court finds the interests of justice do not require the defendant to recite a factual basis. The court finds that the contents of People's Exhibit number 1 satisfy the required proof elements for added count 2. The defendant there is found guilty of count 2. Count 1 will be dismissed at the time of sentencing. We're going to have a pre-sentence investigation report done. I want to have no more about him. I don't, because we don't have the defendant here today, do we? I mean, the victim.
We would have to allow for
Yeah.
victim notification.
So, yeah, so I'm going to have a PSI prepared. That report will be conducted by the Michigan Department of Corrections. It will include a description of offense, description of the pretrial agreement, any statements or information provided by the defendant. Information maybe from the victim, prior criminal history, health records, that your health information as well. Mr. Johnson, there's a packet that's been given to the bailiff. He's going to give that to you at the jail. You're going to complete it, file the answer it, turn it back in. You'll be subject to an interview with an agent from that office, and you have the right to have Mr. Harrison present during that interview. And Mr. Harrison will meet with you prior to coming back to court to discuss the content of that PSI. Each side has the right to make objections or request corrections to it before the court gives a sentence based upon it. Your father also will have the right to appear in this court and make a statement as a victim. Anything else, Ms. Dahl?
Your Honor, I have an order for DNA samples since he was arrested on a felony. Do I fill out the top portion or does the court?
Who was well, he's going back to the jail, so just put in Wexford County Sheriff's.
Yeah.
And I'll sign it.
Okay, I'll fill in the date and the conviction
All right. and
right
then
now, and I'll get it to the court.
So, hold on. What she's talking about, sir, is that there is a DNA swab that will be taken. That's what I'm ordering to be done. All right? It's real simple. It's done at the jail. They just put a Q-tip in your mouth. Doesn't take more than 10 seconds. Mr. Harrison.
In light of Mr. Johnson's entry of a plea to a misdemeanor charge, and in light of the fact that he has amassed, I count 89 days jail credit up to this point, I would simply request that his bond be modified to PR pending the return to court for the sentencing.
Ms. Dahl, do you have a response?
Understanding is that previously, Mr. Johnson did not have a place to live, as his father, who he was residing with, no longer wants him there.
Right.
Prior bond orders were that he not have contact with the victim or the residents, and he had GPS tether if he had a place to go. I'll leave it up to the court whether the court feels that personal recognizance bond is appropriate, but if it does, I would ask that those conditions remain.
Mr. Harrison, you're still standing. Anything?
Well, I agree with Mrs. Dell to the extent that the GPS tether requirement may prove to be a challenge, and that it is our current intention for Mr. Johnson to at least temporarily align himself with the New Hope shelter. That's not going to be permanent. He's going to move on from there, but I have no qualms of his ability and his wherewithal to show up for court dates and meetings with me and that sort of thing.
Well, the thing is New Hope Shelter is not a hotel.
Correct.
You can't control whether or not you get a bed there. Plus, you often have to leave from the shelter during the days. And I don't have a location or residence to which to send him. And I'm concerned about some of the mental health issues that I have gleaned from the today, as well as the preliminary exam transcript. And while I do understand that there is a general perception or presumption of just fines and costs, that does not apply to domestic violence. Therefore, the court denies the bond modification and revokes bond and remands the defendant to the custody of the Wexford County Jail. All right, we'll be back here in about probably 4 weeks. Thank you. We're adjourned.
Thank you.